Thank you, Mr. Chairman and Mr. Attorney General. Thank you for being here with us. When you were last before us in December, I asked you about a case involving the seizure of a domain name called thejazz1.com for alleged copyright infringement. In December, you said you were unfamiliar with the case, but that you would certainly look into it and get back to me. Since that hearing, not only have I not heard from you, but new details have surfaced, and therefore I'd like to revisit the issue. To refresh everyone's memory, the Jazz One is a blog. It's a blog dedicated to discussion of hip-hop music. And in November of 2010, the domain name of the site was seized as part of ICE's operation in our sites and on an application by prosecutors in your department. After the government seized the domain name, the owners filed a request for the government to return it to them, and under the law, the government had 90 days to initiate a full forfeiture proceeding against the domain or else return the property. However, in this case, that deadline passed with no action. When the website's lawyer inquired with the department's lawyers, he was told the government had filed an extension but under seal. The website was given no notice, and they were never given an opportunity to appear in court and to respond. And I have talked to the representative of the website, and he assures me that he made diligent efforts to try and actually appear and make his case. When he asked for proof that the extension existed, your department's lawyers basically said they'd have to trust them. Now, this happened 2 more times. Finally, in December of last year, more than a year after the original seizure, the government decided that it didn't, in fact, have probable cause to support the seizure and return the domain. Now, we now have unsealed court records, and we know that ICE and your department were actually waiting for the Recording Industry Association of America, which made an initial allegation of infringement, to provide detail, apparently proof. And I've reviewed the affidavit, which I'd ask unanimous consent to put into the record, that in September of 2011, 10 months after the seizure, the ICE agent was still waiting for information from RIAA to give probable cause. Now, here's the concern I have. Blogs are entitled to First Amendment protection, and I think it's the law that you have to have probable cause before you seize things. You can't seize things, have secret proceedings in the federal court, and then a year later come up with probable cause. So here's my question for you. It looks to me, and I'd say another issue as to websites. I mean, this isn't like a car that's stolen is going to disappear or a bag of cocaine. It's a website, so the evidence can be completely preserved even without seizure. So I think the issue of seizure does need to be visited with us. But I want to know what the department's posture is. If an ICE agent is behaving recklessly in an investigation, as it seems to be in this case, don't the prosecutors in your department have an obligation to reject faulty affidavits? Do you think that the ex parte process that was included here is proper and consistent with the First and Fifth Amendments to seize a domain name that has First Amendment protection for a year without any opportunity for the owner to be heard?
As with all domains that are seized, or were seized, I guess, in operation in our sites, I believe that the seizure that you referenced was conducted pursuant to a lawful court order and the procedures that the department followed in that case, including the ex parte procedures you mentioned, were consistent with the statutes that authorize the seizure and forfeiture, and also consistent with due process protections that those statutes provide.
So you're suggesting that the representation, which turned out to be false under the initial affidavits, which I again would ask to be made a part of the record, those false affidavits were sufficient to have ex parte communications and sealed and secret proceedings in the federal court to suppress this speech for over a year?
No, I mean, clearly, if material was submitted that was false in an underlying affidavit,
Or at least misleading, if I may say
that would not be an appropriate basis for action on behalf of the government. The seizure and forfeiture of property is a really powerful tool that the government has. It has to be used judiciously, and to the extent that there are problems along the lines that you have described, that would be of great concern. Though we should not be in court trying to do the kinds of things that I have described here, domain name seizures, if the underlying material is not consistent with the facts. That's something we shouldn't be doing.
Well, as I say, in last December, you were going to get back to me, and I know you have many things to do, but I would appreciate, I'll ask again, if I could get a report on this specific case, and certainly, as my colleague, Mr. Waters, has mentioned, there are important enforcement issues that need to go on. I do not disagree with that. But we also have to be very careful about the First Amendment and the Fifth Amendment. And I hope that you do not disagree with that.
Thank